I'm a professor of law and the founding director of the Center for Immigration Law and Policy. In celebration of Black History Month, the center wanted to hold a conversation about birthright citizenship and the connections among African Americans and Asian Americans and other immigrants. So thank you so much for being here today to be part of our conversation. I am pleased to welcome up here in a few minutes Professor Martha Jones, who is our lecturer for today. But before I do that, I also want to acknowledge important people in the room. We've got Chancellor Nancy Cantor, who is here with us, as well as our very own Dean, Dean David Lopez. Thank you. One of the ABLS students, Courtney Bolden, will be introducing our speakers for today. So thank you again.
Good morning. Professor Martha Jones is Society of Black Alumni Presidential Professor and Professor of History at Johns Hopkins University. She came from the University of Michigan College of Literature, Science, and the Arts, where she was a Presidential Bicentennial Professor, Professor of History and Afro-American and Afro Studies. She was a founding director of the Michigan Law School Program in Race, Law, and History, and a senior fellow in the Michigan Society of Fellows. Professor Jones is a legal and cultural historian whose interests include the study of race, law, citizenship, slavery, and the rights of women. Born in Central Harlem in New York City, Professor Jones holds a PhD in history from Columbia University and a JD from the CUNY School of Law. Prior to joining the Michigan faculty, she was a public interest litigator in New York City and a Charles H. Revson Fellow on the Future of the City of New York at Columbia University. Professor Elise Boddy is a nationally recognized expert in civil rights, a professor of law, Henry Rutgers University professor, and Judge Robert L. Carter Scholar. Professor Boddy teaches constitutional law, civil rights, and state and local government law. Before joining the Rutgers faculty, she was the Director of Litigation for the NAACP Legal Defense and Educational Fund. Professor Boddy is the founder and executive director of the Inclusion Project at Rutgers Law School, which seeks to advance racial inclusion and equity, and is also a founding trustee of the New Jersey Coalition for Diverse and Inclusive Schools. She's a leader in the current effort to integrate public schools in New Jersey and has been a major force behind the case Latino American Network et al. V. State of New Jersey that challenges school segregation statewide. Thank you.
Good afternoon. Sorry about that, missed my cue, but very happy to be here. I also want to extend greetings and thanks, first and foremost, to the Center for Immigration Law, Policy, and Justice. It's really an honor to be a part of this important project. I want to thank Professor Villazor and everybody who made it possible for me to be here. It's a pleasure to meet Dean Lopez and Chancellor Cantor, who was, as I just reminded her, once was my provost. So I'm going to claim her just a little bit, though you all have pride of place right about now. So I'm going to talk today about the question of birthright citizenship, mostly as a historian. I want to tell you a story, in fact. What I think is really, I'll suggest to you today, the first chapter in the long saga, the troubled story of birthright in the United States. Of course, this is a moment in time, 2019, when we find ourselves very much situated in yet another crisis of law, but of human rights, one that is turning in an important degree to an important degree on the question of birthright. Maybe some of you followed a couple of weeks ago, it was just a couple of weeks ago, when Senator Kamala Harris from California announced her bid for the presidency of the United States. And I would say it took about 45 seconds for the trolls to begin to scrutinize Harris herself, her family, their history, their immigration status, and to begin to make the argument that because Harris's own parents were immigrants not naturalized, that she too should be deemed a non-citizen and thus not eligible for the presidency. Back in October of 2018, President Trump was revealed in an interview with Axios to have not only offered up his own views about birthright citizenship, but he proposed that he had the authority by way of an executive order to transform, if not the literal terms of the 14th Amendment, certainly our interpretation of it, such that the children of so-called unauthorized immigrants would not be deemed birthright citizens. It's a mistake, I think, however, to ascribe this debate to, if you will, the era of the Trump administration. Since at least 2009, in every year, Congress has introduced what it has termed the Birthright Citizenship Act. And this act has year after year proposed to interpret that somewhat murky language in the 14th Amendment about being subject to the jurisdiction of the United States. It is proposed to interpret that language for the nation to again exclude the children of unauthorized immigrants. Reconstruction is one starting place for this story, and Reconstruction, we know, brought about a legal revolution, but one that was, I would say, unfinished at best. Ratification of the 13th, 14th, and 15th Amendments marked a sea change. Slavery was abolished, equal protection to all citizens was guaranteed, voting became the subject of constitutional oversight. Reconstruction fundamentally reordered the nation's constitutional scheme, establishing new and far-reaching federal supremacy and laying the foundation for the culture of rights that was to follow. Since their ratification, the Reconstruction amendments have proven to be both highly durable and hotly contested. Birthright citizenship is among the most far-reaching and disputed today of Reconstruction's legal legacies. The 14th Amendment broke a silence in the Constitution of 1787 when it provided for birthright citizenship. And with the ratification of that amendment, birthright assumed a central role in arbitrating national belonging. The principle of jus soli, the right of the soil, had a long history in English common law. Still, it penetrated widespread consciousness in the U.S. only after it was constitutionalized in 1868. Many 21st century Americans may take for granted or even be unaware how birthright silently bestows upon them and their children citizenship. Still, this provision has always required careful interpretation. It has faced outright challenges. Among us are legal and political scholars of citizenship who echo pundits and the President, asserting that a reinterpretation of the Constitution's birthright provision is permissible and in order. Even among us, birthright is a live question today. It's been so for nearly 200 years. Indeed, it's difficult to point to any moment in the past 2 centuries when citizenship was not the subject of debate. The Reconstruction-era ratification of the 14th Amendment, in this sense, is best understood as an important but hardly definitive moment in the history of birthright. The events of 1867 and 68 followed on the heels of pre-Civil War debates over the status of free African Americans. And they were followed by a questioning of birthright when, at the century's close, the status of children, the children of Chinese immigrants, children whose parents were ineligible for naturalization themselves, were claimed to be perhaps non-citizens. We learn that while the 14th Amendment resolved the fundamentals of citizenship for former slaves, it did less well for the U.S.-born children of immigrants who in the 1890s and today face questions about where they are situated along the nation's borders of belonging. So it's 1824 in Baltimore, Maryland, and a convention of former slaves has gathered to contemplate their fate in the United States. And they face two grave and pressing circumstances. The first is a movement that we call colonization. Colonizationists had their roots in the 18th century, had their roots in a critique of slavery, not a radical critique that called for slavery's immediate abolition, but a critique of slavery, at least to the degree that colonizations anticipated that the institution of slavery would ultimately end, perhaps over years, over decades, over a century. But what really concerned colonizationists was the question of a post-slavery society. And colonizationists organized, raised funds, outfit ships, found colonies like Maryland and Liberia in an effort to plan for the ultimate removal of former slaves, of Black Americans from the nation. Colonizationists work out of the premise that the U.S. can only go forward as a white man's country, and their work puts pressure on former slaves in the United States to, in essence, self-deport. The second circumstance is what we term black laws. And these are, generally speaking, state and to some degree laws that come out of municipalities that aim to regulate the day-to-day lives of former slaves, where people can live, what sort of work they can do, the organization and the regulation of their families, their communal or associational life, fraternal orders, churches, political organization. Black laws regulate the degree to which people can travel, can come and go. Can they own guns or dogs? Black laws regulate the everyday lives of former slaves, but they are also connected to colonization in that their ultimate purpose is to make life in the United States so uncomfortable, so unmanageable, so untenable for former slaves that once again they will self-deport. So, back to that convention. Before their deliberations were done, the delegates passed a resolution. We consider the land in which we were born, in which we have been bred, our only true and appropriate home. I hope you hear the beginnings, one element in an opening salvo, a claim to birthright citizenship. Hezekiah Grice later deemed this period his Dred Scott case. Ideas about the legal status of free African Americans were being tested, and as a longtime Baltimorean, Grice stood at a sort of crossroads. Should he remain in Maryland or venture to a place where citizenship and rights would not be denied because of color? There might be, he believed, some promise in staying put, if only he could be certain about his status as a citizen. Grice had come of age in the wake of Maryland's 1802 elimination of Black voting rights. He was freeborn in rural Calvert County. As a teen, he had been bound out as an apprentice by one of those black laws. By the 1820s, he had migrated to Baltimore, was formally schooled, and he associated with figures like Benjamin Lundy and William Lloyd Garrison, radical editors of Baltimore's anti-slavery weekly, The Genius of Universal Emancipation was the paper's name. To grapple with the question of citizenship, Grice, along with William Watkins and James Deaver, founded what they called the Legal Rights Association. The three put questions about rights into the air. Deaver, for example, provided over a Black anti-slavery meeting. There were toasts, things like, Give us our rights, and our motto shall also be our country right or wrong, and emancipation without immigration, but equal rights on the spot. These were the sort of men who asked whether the Constitution provided Black Americans with a birthright citizenship and thus promised to them its privileges and immunities. Together, they sought to learn what they needed to know and to secure allies in efforts to ascertain the legal status of the colored man in the United States, as they put it. William Watkins explained the thinking of the Legal Rights Association, and he began not with the Constitution, but with the Declaration of Independence. He wrote, "This imperishable document, whose attributes are truth, justice, and benevolence, has declared to the world that liberty, in the full sense of the word, is the birthright of all men, consequently of every colored man in the Union. That we are not only born free, but have by virtue of our existence certain rights which are emphatically termed inalienable." Did the Constitution affirm the Declaration's natural rights ideals? Watkins continued, "The Declaration of Independence is our advocate, and we hope it will yet be ascertained whether or not the Constitution of the United States secures to us those rights which the Declaration so freely accords." This sort of close reading led to important questions for Watkins. He wrote, "Why, I emphatically ask, should we not enjoy those rights which all must confess have been wrested from us without the shadow of a crime? What evil could possibly accrue from the adoption by the white people of this nation of a liberal, just, and humane policy towards 300,000 of the home-born citizens of the United States?" Black laws and colonization were an abrogation of birthright in the view of the Legal Rights Association. So these men worked out their own ideas, and they also worked out their connections to white legal thinkers, building a case. Early on, they turned to a local authority, John Latrobe. A lawyer and philanthropist, Latrobe was a colonization advocate, not the likeliest of allies, but frankly, he was available as an accomplice and for a fee. There was some common ground between Latrobe and the Legal Rights Association. He was a lawyer who had built his early reputation in part by representing free Black men and women. Once established, Latrobe was sought out by Black Baltimoreans for his advice. So when in the summer of 1827, William Watkins called on Latrobe, the timing was no accident. Baltimore's mayor had issued a black law, ordering basically a curfew, an 11 p.m. curfew that would be imposed only on African American residents of the city. Watkins posed to Latrobe a question: was such an order constitutional? Latrobe obliged with an answer. I'm sorry to tell you that in his diaries, he never tells us what the answer was. But we do know that he provided Watkins with an opinion on the mayor's notice and its constitutionality, and months later, he's careful to record the Legal Rights Association still paying off his fee. So hiring Latrobe turned out to be just the beginning for the association. Baltimore was home to many of the country's best legal minds in this period. And just a half dozen short blocks west of the city courthouse lived an expert, William Wirt. He was the former U.S. Attorney General, a formidable trial lawyer and appellate advocate who was admired for his arguments in cases like McCullough versus Maryland and Gibbons versus Ogden. Wirt firmly established for the first time the office of the U.S. Attorney General through development of its structure and its record keeping. He ran the office of the Attorney General from 1817 to 1829. Wirt really emerged fully formed for African Americans through his work representing Native Americans in the Cherokee cases in 1831 and 32. And African Americans looked to the status, the circumstances, and ultimately the tragic Trail of Tears, Indian removal, as a sort of specter of what their futures might entail. So these two matters, Indian sovereignty and free black citizenship, were not closely linked in a doctrinal sense, and still the Cherokee example was a cautionary tale for free African Americans who worried, as one commentator put it, that if a colony was formed for the blacks in the US, they would in a short time be removed, as had been the case with the poor Indians. And this is certainly what Hezekiah Grice had in mind when he called on William Wirt. First, the two talked dollars and cents. Wirt's fee was $50, and Grice was prepared to pay it. He wanted an opinion on the legal condition of the free colored man in the United States. Wirt then imposed a second condition. He said that Grice had to have his questions written out in a proper form. So Grice found another lawyer, John Tyson, who was a state legislature and leaned toward anti-slavery thought, and the two drafted a series of questions based on the Constitution and relating to the rights of citizenship of free black men. When Grice returned, Wirt dodged. It was, he remarked, a delicate matter for an officer under the government, and he wasn't in a position to answer these questions as they should be. It was a thinly veiled brush-off. Wirt was by then a private citizen, not a public official. He clearly had been associated with controversial or provocative questions. The Cherokee cases were one example. But in the end, Wirt offered only a sliver of encouragement, agreeing that Grice's questions deserved to be answered by the best legal talent of the land, as he put it. And he sent Grice to Philadelphia to attorney Horace Binney. Binney was someone also held in high esteem. He had collaborated with work on the Cherokee cases. He'd served as a legislator in Philadelphia and in Washington, or I should say Harrisburg and Washington. He was a leader on anti-slavery conventions in the 1820s. He even had represented free African Americans in Philadelphia, the leaders of the African Methodist Episcopal Church, when white Methodist leaders had tried to seize their property. So Grice went to see him in Philadelphia, and despite Binney's track record, like Wirt, he sidestepped Grice's request. He pleaded age and poor eyesight. And he sent Grice to yet a third attorney, John Sargent. Sargent also had a reputation, had worked on the Cherokee cases. He'd been an anti-slavery ally. Binney said he has the requisite character and the weight that the question demanded, and Grice went to see him too. Sargent said, I'd be happy to help you, but only if Binney will sign off on my opinion. Well, as you can imagine, it all falls through. And this is characteristic of what former slaves encounter when they begin to engage with lawyers, with judges, with lawmakers overall, is a kind of fumbling, is a kind of sidestepping, is a kind of uncertainty that creates not only a legal, but a political and social and cultural climate in which former slaves have many reasons to doubt, on the one hand, where they stand before the Constitution, but also many reasons to organize, to press, and to attempt to build their case to national belonging. So these are formative moments. The scales of these deliberations shift between grand public debates like political conventions and these intimate law office encounters. Men like Watkins and Grice and Deaver are learning lessons that no text could teach. The Constitution would be a touchstone in their claim to citizenship, but the text alone was not enough. There were arguments to be honed, minds to be influenced, and the stakes were high. Colonization and black laws did not on their face require the removal of African Americans, but their effect was to create a climate in which the pressure to self-exile or self-deport remained heavy and persistent. So the first debates around birthright citizenship predate Reconstruction by many decades. And lawmakers from the 1820s forward will be moved, pressured, compelled by the claims of former slaves to take up these questions. Congress, twice in the 1820s, took up this puzzle of Black Americans and Birthright, it too fumbled. In 1821, a clause in the proposed constitution for the new state of Missouri provided, quote, "The state should adopt laws to prevent free Negroes and mulattoes from coming to and settling in the state under any pretext whatsoever." Congress members, as they reviewed the Constitution, asked, would a prohibition against the in-migration of free persons of color violate the Constitution by drawing an impermissible distinction between citizens of different states? It was a rancorous, extensive debate, filling many, many, many pages of the annals of Congress today as we read them. Some Congress members took the view that if a person was not a slave or a foreigner, they were a citizen of the United States and had the right to go into Missouri like any free person. Others saw no conflict, the implication being that free Black Americans were not citizens and Missouri was at liberty to bar them. Well, what did Congress do? A curious thing. On the one hand, it permitted this language in the new state constitution to remain, the provocative language, and it admonished Missouri. I'm not sure quite what admonish means in this context when Congress does it, but okay. It admonished the state not to violate the rights of citizens, including free citizens of color. 5 years later, in 1826, Congress came back to this question. This turned on the dispute involving a man named Gilbert Horton, who was a free Black New Yorker who found himself detained in Washington. He was accused of being a fugitive slave and then threatened with sale into slavery for his inability to pay the jail fees, even after it was established that he was a free man. Horton was extracted by no one less than Governor DeWitt Clinton of New York, who advocated for Horton because he deemed Horton to be a citizen of the state of New York. And this confusion led a New York Congress member, Aaron Ward, to place on the floor of the House an inquiry, really asking Congress, which, as you know, is writing the laws for the District of Columbia, asking Congress to now ensure that there's nothing left on the books that might put other people in the untenable circumstances that Citizen Horton had found himself. Well, this erupts into a debate, not because Congress members object to this inquiry as a general matter, but what they object to is that Ward has termed Horton a citizen in his proposal. And so Ward takes back the word and the inquiry goes forward. You see the way in which lawmakers really are not at all of one mind. Attorneys general are also caught in this debate. William Wirt, who we met a few moments ago in 1821, was asked formally, could free Black men command American merchant vessels when federal law barred non-citizens from commanding such ships? Here we learn that Wirt knew a lot more about this question when he met Hezekiah Bryce than he ever let on. And Wirt's answer was a kind of equivocation. He said, well, it depends. Good lawyer's answer. It depends. If free Black Virginians, and the case involved a Virginian, free Black Virginians were full citizens of their state, then they were U.S. citizens for the purposes of commanding vessels on the coast. And if they were not, then they were not. 3 years later, or I should say the next decade, in the 1830s, Roger Taney is now Attorney General of the United States. And he gets posed the same question. Well, Taney, it won't surprise you, says absolutely not. Regardless of how Virginia or any other state might regard a free man of color, he must never be deemed a citizen of the United States. So, we've got attorneys general who disagree. Our last touchstone is the courts. And here, the infamous case of Dred Scott is oftentimes, where we begin this story. Chief Justice, now Chief Justice Roger Taney, is going to conclude that no Black American is a citizen of the United States, be they enslaved or free. Well, if you've studied Dred Scott at all, and I know you all have, you know that there are two dissenting opinions. And Justice McLean argues, in fact, that birthright is the arbiter of citizenship in the United States. McLean will then go on, as he's riding the circuit, to limit the applicability, limit the scope of Dred Scott. In Mitchell versus Lamar in Illinois, he will conclude that a free black man not descended from slaves, distinguish the facts of Dred Scott, not descended from slaves, is a citizen of the United States. So it would be a mistake for us to consider Dred Scott as having settled these questions, because it did not. More familiar to most of us is the story of the Civil War and Reconstruction and the ultimate constitutionalization of birthright. Here in 1862, we have a first salvo, now from Attorney General Edward Bates. Bates will issue an opinion. He gets asked again, can free men of color pilot ships along the coast? And Bates says, yes, they can. He reviews the decisions or the opinions of Wharton Taney. He studies the question and much of what has come out of these debates, and concludes that free men of color are either aliens or citizens. There is no intermediate category in the United States, and birth prima facie confers citizenship on free men of color. Congress, by 1866 and 1868, first in the Civil Rights Act and then in the 14th Amendment, will make birthright the law of the land. Where I want to leave us, though, is what happens after the 14th Amendment is ratified in 1868. The first thing Congress wants to do is amend the Naturalization Act of 1790. That act limits naturalization to white persons. And Congress now wants to extend the possibility of naturalization to people of African descent. Charles Sumner says, let's take out the word white and be done with that. No way. Why not? Because to take out the word white would open the door for naturalization to who? To Chinese immigrants. To Chinese immigrants. And so I hope you see now the linchpin here. This question will plague the lives of Chinese immigrants and their children for the decades all the way until 1898. Customs officials, attorneys general will develop a view that suggests that somehow Chinese immigrants and their children are indelibly foreign, not subject to the jurisdiction of the United States, but instead loyal to the Emperor of China, such that they are not birthright citizens, and hence can be, as becomes the example of Wong Kim Ark, hence can be stopped at the border when they attempt to re-enter the United States and detained as unauthorized aliens. This question will take us all the way to 1898 and to the U.S. Supreme Court, and a final resolution of that next chapter, one in which the court will affirm that the children of Chinese immigrants, even as their parents, are deemed ineligible for citizenship by virtue of not only the Naturalization Act, but of course the Chinese Exclusion Acts beginning in 1882, that even those children of immigrants are citizens of the United States by virtue of birth. So I'm going to take one more minute. Because I often get asked, what do I think this history has to do with our present time? So I'll put a few things out there for you that maybe we can talk about. The first is the tragic parallel. That the story of African Americans in the early 19th century is, for me, a tragic parallel to the circumstances of particularly unauthorized immigrants in the United States today. Communities that build families and institutions that are part of our social and political and economic fabric, who live in a kind of terror
that is rendered by the legal limbo of their lives. We might ask ourselves, what is a democracy? And isn't a democracy in part always characterized by people aiming to get in, to belong, to enjoy the full benefits of democracy? African Americans pounded that door for decades before the Civil War makes it possible for them to step in. Contests over citizenship are an ordinary part of our national history. There is nothing aberrant, there is nothing un-American, there is nothing out of bounds or illegitimate about people who are said to be outside, asking, claiming to be inside. How that will be resolved in our own time, I think we still don't know. Finally, history is just not enough, I don't think, in the 21st century to launch a full defense of birthright. We have to ask ourselves what we think birthright does today in our own time. And in my view, and it may be just my view, birthright continues to be an essential bulwark against the effects of racism, of xenophobia, and more in our national regime. That birthright has extended its benefits far beyond former slaves or the children of Chinese immigrants. That in every generation, those who are despised in this country are despised, and that's another lecture on another day. But those who are despised, their children continue to be citizens of the United States. That, at least that baseline, is unassailable on our regime, and at least for me, gives me food for thought for why it should continue. So I want to thank you all very much for the time and the podium, and I think I'm going to turn it over to Elise Bright.
So first of all, I want to start by thanking Professor Viazor for bringing us all together, for inviting Professor Martha Jones to speak with us. I want to acknowledge Chancellor Cantor, who is a fighter and someone who I admire so much. I want to sort of pick up from where Professor Jones left off, to try to connect the themes of this extraordinary book, and it is an extraordinary book, and I recommend it to all of you, because it is so rich in its historical content. I want to start with just a quick story. Some time ago, I went to a funeral for a black man who had died in his late 80s. And he had grown up poor, and he had struggled a lot in his life. But he eventually made a way for himself, and he became a teacher. And I'll never forget the way that the pastor described him in her eulogy. And she started out by asking us, she said, have you ever noticed when you walk down the sidewalk that sometimes there are these little green sprigs of plant life that have broken through the cement? Right? They push up through the cracks, right? Sort of demanding that they be recognized. Right? And she said that this man had been like one of those green sprigs because he had managed to find the cracks, right, and to will himself through them. And I thought about his story when I was reading Birthright Citizens, because it is a book about African Americans who pushed through the cracks, right, the crevices, the gaps and ambiguities in the law to create spaces of freedom and dignity. Professor Jones, as a disciplined historian, I've heard her say this before, cautions that we not look to draw lessons so much for the future from these stories of the past. But I do see several themes in the book that I want to connect to the struggles of African Americans throughout history. Just five themes, and I'm trying to Okay, so we'll go through them rather quickly. So theme one, the story of freedom begins not with lawyers and judges, but with ordinary people. It's easy in a law school to think of rights as being laid down by formal law that is created and interpreted by those with formal legal authority, statutes that are passed by elected representatives, cases that are interpreted by judges, right? But formal law didn't do anything, right, for African Americans in this period. Law, quote, for African Americans in antebellum Baltimore was the everyday law that was crafted and shaped and nurtured in local spaces by ordinary people who did extraordinary things. Right? They wanted to be recognized as citizens, but they did not sit on the sidelines and wait for the debates about their status, their citizenship. Right? As Professor Jones says, they wove themselves into the fabric of Baltimore. They engaged in legal practices by suing in court and consenting to be sued, because to be recognized in a legal form was itself a form of a victory. They took to the sea as mariners, learning the rituals and routines of law by studying and absorbing the rules and customs on ships. They exercised rights by incorporating their churches and creating documents that define the lines of authority among church leaders. And this is my favorite. They even exercised rights by asserting their presence, right, the very right to be in the streets of Baltimore. And they did so despite, or perhaps even in defiance, of the threat of colonization, of black laws, right? The threat of being forcibly removed from the country and being micromanaged within their spaces. And when the Dred Scott decision, which declared that black people had no rights that the white man was bound to respect, they continue to act like rights-bearing people almost as if nothing had happened. And they won their rights, as Professor Jones says, by acting as though they had them. By acting as though they had them. And that reminded me of Barbara Rose Johns, who as a 16-year-old in 1951 led a student strike to protest substandard facilities in her segregated high school in Virginia. Or now Congressman John Lewis, who as a young man led a march across the Edmund Pettus Bridge in Selma, Alabama, to protest for the right to vote and was nearly beaten to death by an Alabama state trooper. Theme number 2, progress begins with an idea and a demand. Progress begins in the imagination through an ability to see what is not there, to conceive of a different kind of system, a different way, a different kind of country. And it's hard not to be struck by the tremendous faith of black people in antebellum Baltimore that law, in the words of William Yates, could be made right. Because they could have left. They could have gone to Trinidad and Haiti or Liberia. That would have been so much easier. But instead they stayed. Right? They laid claim to their country by reminding those who would listen that they had built this country through their uncompensated labor and slavery, through the communities that they had established. They demanded their rights. Give us our rights, and our motto shall be also, our country right or wrong, and emancipation without emigration, but equal rights on the spot. And so I think of Fannie Lou Hamer in the Civil Rights era, who organized the Mississippi Freedom Summer and co-founded the Democratic Party. I think of Reverend William Barber today, who has led the Moral Monday movement in North Carolina to protest racially oppressive and discriminatory laws in that state. Okay, theme number 3. Freedom is precarious. It is precarious. Right? In Birthright Citizens, we see the small incremental steps to citizenship, but we also see the precariousness of freedom. Because even as free blacks in Baltimore claim their rights to citizenship, forces are at work to strip them of their rights to property, to annul the titles to their churches. They risk the possibility of being sold out of state if convicted of crime, of being barred from returning to Maryland if they leave the state, the threat of being kidnapped and sold down south. So we see the precariousness of freedom in our lifetime too. Because even as we have formal rights, right, the 1965 Voting Rights Act, we have the 2013 Shelby County decision by the Supreme Court that gutted the Voting Rights Act. We have the 1968 Fair Housing Act, but we still have persistent entrenched segregation in housing. We've won protections under the Fourth Amendment, and yet black people are still gunned down by the police in the streets. People think that progress is inevitable. Right? Progress is precious, but it is not inevitable. It does not move in a straight line. Some people like to say that the arc bends toward justice. That's not true. It does not bend toward justice. You have to bend it toward justice. Theme number 4, the struggle is intergenerational. What is so remarkable about William Yates and William Watkins and George Hatchett, that Professor Jones talks about in her book, is that they must have known, or at least strongly suspected, that they would not live to see the fruits of their labor. They would not live to see citizenship in their lifetime. The late John Payton, who led the NAACP Legal Defense Fund, while I was there, used to say civil rights work is not a marathon. It is a relay race. You do what you can in this generation, and then you hand the baton off to the next generation. And that is because racism is persistent. It adapts. As soon as you think you've beat it, it comes back roaring into a new form. So you do what you can to make life better for the people who come behind you, with the hope that they will do the same for those who come behind them. Last thing, in the minute that I have left. All right. The past is present. The sociologist Boaventura de Santos writes that even laws that have been revoked remain present in the memories of things and people. Legal revocation is not social eradication. So we see that today in the struggles to remove the symbols of the Confederacy from public spaces. We see that in the pictures of certain elected officials in blackface, who remind us, as William Faulkner wrote, that the past is not dead, it is not even past. And so we continue to contest and defy and try to displace the past through formal law, statutes, and cases. But just as Black Baltimoreans did in the years before the Civil War, through the idea that the country could be made better and the demand to make it so, we also see that demand today in the form of Black Lives Matter. We see it in the protests by the people in the Brooklyn jail who banged on the windows because they had no heat. We see it in the undocumented people who lay claim to U.S. citizenship by asserting their contributions to this country, their labor, the communities they've created. We see it in the people who present themselves for asylum at our southern border. And so I thank you, Professor Jones, for Birthright Citizen, for helping us to see the granularity of rights beyond formal law and the many different pathways that ordinary people who do extraordinary things take to help us secure our freedom. Thank you very much.
We have about 5 minutes for feedback, comments, question. I'm just going to get rid of that. But we do have another mic. So and in the interest of time, it might be good to just ask for groups of comments and feedback. What can I ask you to come up here? Thank you. Are there any questions or feedback? Yes. Thank you.
Thank you, Professor Jones and Professor Body, for your comments. I'm curious, Professor Jones, in your book, I think you put it this way. You say Black people are not objects of the law, but they're subjects. They're creating the law. They're involved in the law. And so when I read your book, I was putting it in conversation with like Khalil Muhammad's book and Erica Armstrong Dunbar's book. Just this relationship between Blackness, citizenship, and the law. And I'm curious about this other side of the law, which deals with crime and Black people's relationship to crime during this period, whether it has to do with fugitive slavery, Frederick Douglass obviously being a Marylander, being a fugitive slave and extolling that, but also when it comes to free Black people in states like Virginia and North Carolina who, for example, refuse to register as free Black people or as citizens of those states in order to defy the law. So I'm curious about how your work is in conversation with how crime also forms a certain kind of citizenship.
There was another comment or question. Can you pass the mic?
Hi, good afternoon. Thank you for your talk. Unfortunately, I didn't get to finish the book, so I might be asking the question in ignorance. One of the things, I really love how you opened the book, situating around the courts and the squatter spaces in New York. and really integrating a discussion of space and place and how these conversations are continued. Thank you for that. One of the questions I had for you is I'm currently researching Black abolitionist work in New York in the 19th century. And one of the reverends here, Samuel Cornish, as you know, wrote a 16-page treatise against the colonization movement to Theodore Frelinghuysen, who was a statesman here in the United States. So one of my questions for the book was, I know you spoke about Cornish a little bit with regard to the Freedom Journal, but I didn't hear you really discuss his piece. So I just wanted to ask why, and then also I wanted to find out, were there other people who were writing these pieces during the period? Because I'm really trying to situate how Cornish's piece might have been received and during this period. So thank you.
Yeah, I can, oh, great. So thank you both for the questions. When I started this book, I was trying to carve out some space separate from the already very robust literature on both freedom suits, fugitive slaves, and enslaved people and former slaves and crimes. So I start out thinking I'm going to write about, if you will, civil matters, and that's where I begin in bankruptcy proceedings and kind of permit applications, things like that. But ultimately I need to understand what's really happening on the ground with respect to Black laws. And that's when I enter into the criminal dockets and spend a great deal of time there. So you only see some of what I learn. There's a great deal still to be written about those kinds of archives. But what was important for me was to discover how unevenly and really, frankly, infrequently the Black laws are actually enforced in a city like Baltimore. And so for folks who read, you'll discover sort of why Baltimore sort of has this sort of character as a legal culture. It's a predominantly free city in a slaveholding state. And because there are these awkward but working relationships between former slaves and white officials, it's partly sort of how Black folks are able to negotiate themselves sort of out of the imposition of Black laws. And it's also the case that in Maryland there's a growing appreciation for, and free African Americans begin to develop a kind of leverage because they are, it's not simply because they are free, but because they are workers and they are understood to be increasingly essential to the economy, to the prosperity of the state, and they are able to leverage that in quotidian ways when it comes to the enforcement of Black laws, and ultimately in 1858 in a state high court opinion that will reject Dred Scott and refuse to incorporate the Dred Scott logic into Maryland precisely because the perception is that people won't work if they don't have the capacity to at least come into a courthouse and protect their persons and their property. So partly the answer is a very particular one to the place I study, but it is about the way in which Professor Body suggested people are using what they have to leverage those relationships and those claims and those contributions, and they're able to extract things from legal culture by way of that. So Samuel Cornish. So one of the things that characterizes this book is that I sort of only glancingly encounter people who have oftentimes been more at the center of our histories of this period and of African American activism in this period. I'm in Baltimore for a reason, because it's a free city and a slave state, because it's home to Roger Taney and William Wirt, because it's home to the largest community of free African Americans in the U.S. before the Civil War. But the short answer to your question is a project called the Colored Conventions Project. And if you haven't already used their resources, the people I write about in the early years are part of what is aims to be a national movement, but is really a regional movement wrought by free African Americans who are excluded from the state politics, excluded from party politics, who create their own political culture, literally. And at the University of Delaware, under the leadership of Professor Gabrielle Foreman, the Colored Conventions Project has gathered together and digitized their proceedings. And so I'm able to find my people there that is where people sort of stand up at a podium and actually give full throat and meaning, express meaning to the kinds of everyday things they're doing in a courthouse. They don't get much chance to stand up at a courthouse and really hold forth. That's not what the archives look like. But I'm able to connect those to the conventions. And so that's for me a go-to place, is I want to understand the intellectual culture of African Americans in this period. There's a critique of the conventions. They don't always accomplish very much on the ground, but if you're interested in ideas, they're an extraordinary place to go. So I wish you good luck with the research.
Yeah, I use that resource a lot.
Great.
I'm going to take the moderator's prerogative and ask just one question, and then I know we're over time. So Professor Jones and Professor Vadi were in a law school setting. Professor Jones, you were a lawyer, right, before you became a historian, and I'm wondering what advice you might have for the role of history in lawyering. Is it, as someone who believes in interdisciplinary work, history informs our understanding of law, but for practitioners, for lawyers to be, why might we think about why should we think about history in law?
Oh no, that's
Oh, that's
historian.
So I'll say very quickly, I was for a decade a legal services practitioner in New York City, and this book is absolutely a tribute to that work and to the clients I worked with. I wrote this book because I wanted to go back to the archives of the local courthouse, the equivalent of the housing court, the family court, and the equivalent. I think in this particular case, it has been striking that the work that history does is set aside myth. There's a lot of myth that surrounds the notion of birthright citizenship. Some of that is casual myth. Some of that is just, an absence of good facts. And some of it is the way in which, particularly those who would do away with, curtail, or otherwise undermine birthright, have characterized it as overreaching, a blunder, outmoded, outdated. These kinds of characterizations are certainly can be challenged in our own political moment, and I'm a proponent of that. But I do think it's been striking how many people just fundamentally don't know the origins of birthright citizenship and don't recognize it as having been a profoundly not simply humanitarian, but really revolutionary turn of events that transformed 4.5 million former slaves into citizens, and really at least aspires to reset the nation on a course toward an interracial democracy. People don't know that about birthright. They know myths about anchor babies and other kind of pernicious ideas. So for me, history sometimes can be a way to combat the kind of myths that misinform our contemporary debates. I'd start there anyway.
I'll just say two quick. I think so. I'm always careful sitting next to a historian, so someone who's a disciplined historian, as opposed to myself, who I read history, but I'm not a historian. And I think you have to be careful with history for the reasons that Professor Jones has described. But you have to be attentive to it, because you can, you see the connections and the parallels between the past and the present. And so if you don't try to understand at least the major markers of history, I think that there are things that you might miss in the present, right? Because I see things that are happening and unfold now, and I say, well, wait, we've seen that movie before. And so it helps to sort of educate oneself about the past in all of its complexity and its granularity. I think is important for people who want to understand how to enforce and execute rights in the modern day, in the present.
Well, thank you. Please join me in thanking our speakers. I also want to thank the Association of Black Law Students for co-sponsoring this event.